Welcome to Legalese of Musicology with the Law Office of Liz Storm. In this first session, we're going to discuss what is a copyright and the basic rights conveyed to the copyright owners. We'll discuss later at what point in the work is it considered to be intellectual property. In a later session, we'll discuss the benefits of copyright registration and licensing with regards to compulsory and mechanical and synchronization, as well as the Berne Convention. So an update on the moral rights and publicity and privacy rights and effects of the European Union Grand Data Protection Rights Act on the music industry. We'll try to go through this quickly and get right to questions, but here we go. What is copyright? The United States Constitution, Article 1, Section 8, states the Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Historical Forms of Music has defined the definition of copyright and legislation since 1909. There are two forms of copyright on a musical work, and sound recordings initially gained copyright protection in 1972. We'll discuss changes to the Music Modernization Act at a later time that also had an effect on pre-1972 sound recordings. Under 17 U.S.C. Section 101, the definitions do not specifically define what a copyright is. 17 U.S.C. Section 102, subsection A, states copyright protection subsists in original works of authorship fixed in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. There are two copyrights for a musical work: the musical composition and the sound recordings. The performance arts form or the sound recording form. Both are available at copyright.gov under one application, provided certain requirements are met. Under 17 U.S.C. Section 101, the definitions of the Copyright Act, sound recordings are defined as works that result from the fixation of a series of musical, spoken, or other sounds, but not including the sounds accompanying a motion picture or other audiovisual work, regardless of the material objects such as discs, tapes, or other phonorecords in which they are embodied. Courts have held to the construction under 17 U.S.C. Section 102, subsection A, as a reminder that the copyright protection must be an original work of authorship fixed in any tangible medium of expression, now known or later reproduced. Artists who put a compilation of songs together that they wrote, as well as musical works that they are performing that somebody else wrote, perhaps will have copyright protection if there is something creative above the selection and original arrangement in the way they have compiled the data. Under 17 United States Code Section 102, subsection A, works of authorship include the following categories: 1, literary works; 2, musical works including any accompanying words; 3, dramatic works including any accompanying music; 4, pantomimes and choreographic works; 5, pictorial, graphic, and sculptural works; 6, motion pictures and other audiovisual works; 7, sound recordings; and 8, architectural works. The United States court has come down firmly that an author must be a human. While the United States Code doesn't specifically define copyright, it does explain what copyright protection does not include under 17 United States Code Section 102 subsection B, stating, "In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. Work not fixed in a medium, short phrases such as United States documents, including all art and music, and works that have fallen into the public domain, not receive copyright protection in the United States." Facts are always discovered, not created, and cannot be copyrighted by anyone. The United States Court has said in Feist v. Rule 499, United States 340 in 1991, that databases or factual compilation copyright protects only those components of the compilation that are original to the author and not the facts themselves. We'll discuss more on privacy of facts later. Under Section 106 of the United States Code, Chapter 17, exclusive rights are given to the copyright owner or claimant. Under this title, the copyright owner has the exclusive rights to do and to authorize any of the following. 1, to reproduce the copyrighted works in copies or phonorecords. 2, to prepare derivative works based upon the copyrighted works. 3, to distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership, or by rental, lease, or lending. 4, in the case of literary, musical, dramatic, and choreographic works, pantomimes, and motion pictures, and other audiovisual works, to perform the copyrighted work publicly. And 5th, in the case of literary, musical, dramatic, and choreographic works, pantomimes, and motion pictures, and other audiovisual works, to display the copyrighted work publicly. And 6th, in the case of sound recordings, to perform the copyrighted work publicly by means of a digital audio transmission. Chapter 17 of the United States Code, Section 101, in the definitions, defines a derivative work as a work based upon one or more pre-existing works, such as a translation, a musical arrangement, dramatization, fictionalization, motion picture version, a sound recording, art reproduction, abridgment, condensation, or any other form in which a work may be recast, transformed, or adapted, or revised, annotated, elaborated, or modified, which as a whole represent an original work of authorship, is a derivative work. We'll talk more about photographs with the Copyright Office. However, photographs are considered derivative works as they are two-dimensional reproductions, perhaps of a three-dimensional copyrighted work. Therefore, you may have to seek permission before taking the photograph and filing it for copyright protection. However, courts are undecided on this. The Northern District of Illinois held in 2008 that photographs are derivative work, and in Florida, the court held photographs are not derivative works. I think on appeal we'll hear some different things, but regardless, you should get permission before taking a photograph of something that you don't own or that is in the public domain. In the United States, copyright duration is the life of the author plus 70 years. To give notice on your musical work, you need to provide the C-circle year and your name or the author's name, or for the sound recording copyright, a P circle with the year and the author name. You file a copyright application with the Library of Congress Copyright Office. A copyright is different from a trademark or a patent in the duration as well. Here, again, the duration is the life of the author plus 70 years. For a patent, it is 20 years, and in the United States, a trademark will last as long as the trademark continues to be used and is productive. You file an application for a trademark or patent with the United States Patent and Trademark Office. Copyright registration will give prima facie evidence of ownership, copyrightability, and facts that are stated in the registration under Chapter 17 of the United States Code, Section 410. In Chapter 17 of the United States Code, Sections 411 and 412, copyright registration will also give the claimant the ability to enforce the copyright, seek an award of attorney's fees, and also statutory damages. Registration will strengthen the value of your intellectual property assets and will also provide support in long-term risk dispute management. Artists who release their music will automatically be assigned an international standard recording code by their distribution company or physical manufacturing company. However, this relatively new international standard recording code, or ISRC, should only be issued to a track and never represent more than one unique recording. An ISRC code can be permanently encoded in the product, and it is the digital fingerprint for your musical work. www.usisrc.org is the website where you can review an application of how to either become a manager of your own ISRC codes or find a company that can issue you one. Record labels as well will issue an ISRC to track their own metadata and artists, similar to the UPC that they otherwise would put on physical product. Songwriters and music publishers are well aware of the International Standard Musical Work Code, or ISWC code, which is a unique, permanent, and internationally recognized reference number that is used by publishers to track their metadata at various performance royalty organizations around the world. After filing your musical works with the Copyright Office, or when your musical work product is finished, right there after releasing your musical work with a record label or on a distribution platform, unpublished works can also be filed with the Copyright Office. The songwriter should register their musical works at a performance royalty organization such as ASCAP, BMI, or CSAC to help collect on their royalties. The featured artist and sound recording copyright owner would then register at Sound Exchange in the United States to collect on their royalties for performance on internet radio. For example, legislative changes in the United States continue to try to monetize revenue for performing artists as well as songwriters on the radio. We'll discuss more about radio as well as these legislative changes in another session. After filing registration with the Copyright Office for your musical work, getting an international standard recording code assigned, as well as an international standard musical work code assigned, do you feel that your work is considered intellectual property now? Do you have the right to give permission to somebody else to perform or cover or use your musical work in a film or to print your musical lyrics in a book? While the copyright claimant has certain exclusive rights that we've covered, others may still use your copyrighted works. In the example of when a songwriter, author has their musical work performed by another artist, a mechanical license will be issued or obtained through either direct from the publisher or songwriter or online through Harry Fox or Songfile, which will charge an administration fee as well as the licensing fee, which is currently 9.1 cents. Harry Fox Agency, for orders under 2,500 units CDs, you can use their Songfile online form to obtain a license for use of the song for which are registered with their database. With regards to artists traveling and performing your musical work in another bar, the bar itself is going to pay a blanket license fee annually to either ASCAP, BMI, or CSAC for those performance royalties. Songwriters and publishers will receive those from the venues and their statements that are issued directly from ASCAP, BMI, or CSAC, which is why it's very important for artists or songwriters to have their cue sheets uploaded at the end of the night or turned in after they performed at a venue so that they can keep track of those performance royalties. Synchronization licenses are licenses that music publishers will issue on their copyright to authorize music to be combined with a visual art. It is negotiated with the publisher and is paid perhaps on a penny rate or based on sales or profits and units sold. The director or producer will either then get a master use license from the artist using their original recording, or else they will hire a band or orchestra to perform the songs that they have licensed from the author, songwriters, or publishers. They may then become the copyright owner of that sound recording version, and they can look at the work for hire definition under the United States Copyright Act. Do you think that copyright registration is important? Can you tell me what a mechanical license authorizes a licensee to do? These are questions we hope to cover in our discussion, and we've covered topics that we will go over in a later session. Thank you, and I look forward to going over all of your questions.